The committee will now come to order. First of all, I want to welcome the members of the subcommittee to our first hearing on the 111th Congress. I am honored to chair this distinguished subcommittee, and I will strive to serve all of us members in an honorable way. I truly look forward to working with everybody on a productive legislative and oversight agenda. In this regard, our first hearing of the 111th Congress is an ambitious one and represents a new addition to the subcommittee's vast jurisdiction. Today's hearing will explore the major issues surrounding the Toxic Substances Control Act, also known as TSCA. TSCA was enacted in 1976 and originally consisted of one title, which today remains at the heart of the statute. While Congress over the years has added additional titles to TSCA addressing individual chemicals and substances, Congress has done very little with regard to Title I. TSCA and Title I have never been reauthorized, nor has it been reformed. And very little oversight has been conducted on the statute's effectiveness. Today, I hope to start a deliberative process that reverses this congressional inaction of the past. By most accounts, TSCA is badly in need of reform. While opinions may vary on the degree and nature of the reforms needed, there is a broad consensus among a diversity of stakeholders that TSCA needs to be reexamined. The scope of TSCA is very broad, and its intent is indeed very ambitious. TSCA is meant to provide adequate data on potential health and environmental risks of all chemical substances and mixtures in the United States. Furthermore, the statute is supposed to provide EPA with adequate regulatory tools to protect the public from unreasonable risk of injury to health or the environment. It is unfortunate that the statute has seemingly been a failure on both of these basic policy goals and objectives. Critics contend that TSCA has failed to generate data on the health risk of approximately 80,000 chemicals currently in use, and the approximately 700 new chemicals that are introduced into commerce each and every year. Even though Sections 4 and 5 of TSCA authorize EPA to force companies to test their chemical products and generate data, the hoops that the EPA must jump through in order to exercise this authority has been much too burdensome. Rulemaking takes years to finalize, costs hundreds of thousands of dollars, and are subject to constant legal action by companies who do not want to comply. As a former EPA Assistant Administrator once said, it's almost as if we have to first prove that the chemicals are risky before we have the testing done to show whether the same chemicals are indeed risky. Furthermore, once EPA has made a determination that a chemical proposes a health and environmental hazard, they have been unable to act on this determination. Section 6 of TSCA provides EPA with broad authority to regulate and ban chemicals. But the burden of proof for action has been so high that banning a chemical is virtually impossible. And I think most Americans would be very surprised to learn that asbestos a known carcinogen that kills 8,000 Americans each and every year, has not been banned by the EPA under TSCA, because the courts have ruled that EPA does not meet its evidentiary burden of proving that asbestos is an, quote, unreasonable risk to the public, end of quote. If TSCA is incapable of providing EPA with the regulatory tools to ban asbestos, then the statute seems to be in dire need of serious repair. And I want to make it clear that I believe re-examining TSCA is not only good for the public health, but it's also good for business. And I do not believe that this hearing should reflect the old divisions of public health versus business, or environmental versus business. And I appreciate the innovative spirit of the American businesses and further recognize the importance of fostering that innovative spirit, especially during these perilous times. But the public's faith in the safety of its products and the chemicals that make up those products have been seriously shaken. And I believe that reforming TSCA and reestablishing that faith will ultimately be a boon for American businesses of every stripe. And today's hearing is only the first in the series on TSCA. Today we will kick off the process in a deliberative manner, and I sincerely hope, that we all can work together in a bipartisan manner. I yield back the balance of my time. And now I recognize the ranking member, my friend, the gentleman from California, Mr. Radonovich, for opening statements.
Thank you, Mr. Chairman, and I appreciate the fact that you called this hearing today, and would like to thank all of our witnesses for taking the time out of your busy schedules to appear before this subcommittee. This is my first hearing as a ranking member of this subcommittee, and I'm very excited to work with you, Mr. Chairman, and the rest of the members of the subcommittee on the broad range of issues that falls under this committee's jurisdiction. One of those issues is the regulation of industrial chemical manufacturing, in what I understand will be the first in a series of discussions of the Toxic Substances Control Act, TSCA, which signed into law in 1976. It was revolutionary at the time of its passage because it bestowed sweeping authority on the Environmental Protection Agency, just 6 years old at the time, to regulate interstate commerce and the life cycle of chemicals manufacturing. Congress has barely touched the core of TSCA, Title I, since it was enacted. Obviously, we all want to make sure that the chemicals produced, imported, and used in this country are safe. I think it's reasonable for us to take a look at TSCA, but I would urge extreme caution about any efforts to touch what is in the law, since TSCA authorities are quite sweeping. It could be that the law is fine and that more funding and enforcement would cure various criticisms. If that is the case, let us be surgical. We should not seek out perfectly functioning laws in an effort to improve or modernize them when neither is needed. Conversely, if something more is needed, we should not use an elephant gun to kill a mosquito. A timely example of legislative overkill is the recently enacted Consumer Product Safety Improvement Act. Members of Congress like myself who supported the underlying reason behind the legislation are now left scratching our heads in frustration as small businesses, thrift stores, and boutique shops in our districts are being forced out of business by the unintended consequences of this otherwise well-intentioned law. A terrible situation in any economy, but particularly during this recession. Unintended consequences are difficult to avoid, but when the potential for unintended consequences are foreseen, Congress should move cautiously. That being the case, a major revision of TSCA, as some of our panelists might suggest today, does pose the potential for a significant threat to small and medium-sized chemical manufacturers. We should be careful to ensure that all of the regulated entities will be able to reasonably comply with whatever changes we might make. In retrospect, neglecting the ability of all entities to reasonably comply with new regulations was a major mistake of the toy bill, and it's something that this committee should look at rectifying. Some folks want to point to states that have already acted to regulate chemicals. It is well known that my home state of California often brags of leading the nation in a variety of progressive environmental and consumer protection laws and regulations. Those same folks forget to tell the flip side of the story, because as California desperately tries to claw their way out of a $42 billion budget deficit, which was resolved the other day, but in May will be back into deficit spending, Congress should think twice before using any of California's progressive models as a national standard. My experience has been that California's environmental regulations have increasingly been a hindrance to the success of small businesses and family farms, which have had a detrimental impact on the state's overall economy. Unfortunately, the European model of toxic substance regulation is far worse, which is exactly what some of us would like to see in this Congress adopt. Currently, TSCA operates as a risk-based statute and tries to mitigate potential problems based on a number of relative factors. The European model operates under assumed hazard or precautionary principle, which assumes every chemical is harmful until proven otherwise. To me, this is backwards, bureaucratic, and at times time-consuming way to regulate anything. Appropriately prioritizing chemicals based on risk is a vital component to effective and efficient EPA regulation. In addition to the correct context and risk prioritization, we must be sure that sound, safe, and reliable science is guiding regulatory decisions at the EPA. There are some who want to regulate industrial chemicals similar to how we regulate pesticides under the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA. My congressional district is one of the largest agriculture-producing districts in the nation, and because of this distinction, I am well aware of the increasing difficulty farmers face when trying to obtain specialty pesticides. Certain specialty pesticides have a greater risk placed on them because they are applied directly to food that we will eventually touch and put in our mouths and digest. However, it's important that we appreciate the context and the exposure under which industrial chemicals are regulated. Under normal use, and unlike FIFRA regulated chemicals, the general public will rarely ever be in a position to ingest the vast majority of industrial chemicals. Otherwise, Congress is mixing apples with oranges. Mr. Chairman, there's quite a bit more I would like to add, as this has been 3 decades since this Congress has seriously reviewed this law. I think this hearing is going to be very useful, and I'm looking forward to hearing suggestions on how we can improve TSCA's performance while doing so in the least burdensome fashion. And with that, I yield back, and I want to thank you, Mr. Chairman.
I want to thank the ranking member, and I want to thank him for agreeing with me right at the start. Our next speaker is my friend, the gentlewoman from Illinois, Ms. Schakowsky, for 2 minutes of opening statements.
Thank you, Mr. Chairman, for holding this very important hearing. When President Ford signed the Toxic Substances Control Act into law in 1976, it was a major victory for environmental protection. For the first time in our nation's history, tens of thousands of chemicals in commerce would be tested to determine their long-term effects on human health and the environment. However, as we review this law 33 years after enactment, it's clear that TSCA needs to be updated and strengthened. In fact, the law presents so many problems that since 1991, the EPA has not attempted to ban a single chemical under the TSCA statute. In a report published last month, the GAO reported that without significant reforms to TSCA, quote, the nation lacks assurance that human health and the environment are adequately protected, unquote. Perhaps most troubling about TSCA is the strict burden of proof the law requires the Environmental Protection Agency to satisfy in order to ban toxic substances. As interpreted by the courts, the lengths the EPA must undertake to meet the burden of proof are so onerous that chemicals known to be extremely hazardous to public health for decades remain outside the scope of TSCA. The perfect example is asbestos. 8,000 Americans die each year from complications associated with exposure to asbestos. In 1989, EPA attempted to use TSCA to issue a rule to ban the use of asbestos, citing the strong evidence of hundreds of studies that conclusively found that asbestos was extremely hazardous to workers and the public as a whole. Despite the overwhelming evidence, the U.S. Court of Appeals reversed the decision, saying the EPA had not fulfilled the necessary burden of proof under TSCA. The fact that EPA cannot use the law to ban a substance as clearly hazardous as asbestos underscores the need for reform. I look forward to hearing from both panels today, who will share their research and direct experience in dealing with TSCA. Mr. Chairman, thank you for holding this hearing. I yield back.
Thank you. Our next opening statement will be from the gentleman from Nebraska, Mr. Terry.
Thank you, Mr. Chairman. I appreciate this opportunity. I think as we progress to see what reforms are necessary, the philosophical differences will be lightest touch versus heaviest touch. I want to relay an experience I had over the district work period when I met with a small business owner or a married couple, employed his brother, and it was truly one of those family-owned businesses called the Wesson Willies. I don't know if any of you know of this company, but they are a kids apparel maker. They have the coolest T-shirt designs, and they're very popular in a lot of the catalogs that some of us may get. This is an example of when we go too fast and don't think through our legislation enough, but as a result of the lead-based toys, we included other chemicals or additives that also have to be tested before they're allowed to come back in. Unfortunately, this company had to make a decision in order to survive that they've offshored some of their apparel making and silk screening of the paint design on the T-shirts. Under the new rules, every different design is treated as a different product and has to be tested at hundreds of dollars per shirt. But amazingly, while that is a financial hardship to do that on every different design and every different size, there's one of the chemicals that's inherent into the paint that's used. And it is such a light level that it barely reads when tested. So the tester said, because it's so light, what you have to do is produce 10 T-shirts, and we will add them up to see if they accumulate to a level that would be banned. Now, the silliness of that is how many of us as parents buy 10 of the same T-shirts for our kids, and that child wears all 10 at the same time. But that's what we caused when we rush into something. So, Mr. Chairman, you're on the right path. It's the right idea. Let's make sure that we don't make the mistakes that we did in the toy bill.
I want to thank the gentleman. Our next speaker is the gentleman from Maryland, Mr. Sarbanes, for 2 minutes to open his statement.
Thank you very much, Mr. Chairman. Thanks for holding this hearing. I'm looking forward to serving on the subcommittee. I think obviously there's a need for this review of the Toxic Substances Control Act, as we've heard in the testimony already. There's a staggering number of chemicals in the EPA inventory, 80,000. But of course the data that we have on those chemicals and others that are introduced each year, some 700 additional that are introduced each year, does not match the degree of hazard that's posed by the chemicals. So just getting the basic data collected and made available is going to be critical. And of course we've heard about the burden of proof issues that need to be addressed. All of those are going to come to light, I think, in these hearings. Appreciate your conducting them, and I look forward to it. Thank you, and I yield back.
Chair, thanks, gentlemen. Our next member of the committee is Mr. Murphy of Pennsylvania for 2 minutes of opening statement.
Thank you, Mr. Chairman, for holding this hearing on the Toxic Substance Control Act. I look forward to hearing testimony from our witnesses on this issue. But before I begin, I'd like to personally welcome 2 witnesses from the greater Pittsburgh area, Maureen Swanson from the Learning Disabilities Association of America, whose headquarters are in my district, and Michael Wright of the United Steelworkers from Pittsburgh, too. Thank you for taking time to come up here, and I'm looking forward to hearing your testimony and your thoughts on protecting children and workers, which are 2 of my top priorities, and I'm sure the priorities are shared by all my colleagues, but these are not mutually exclusive concepts, as proper regulation can do both. My district is home to many chemical companies that directly employ about 8,300 people. These are high-paying jobs with the average employee making a family-supporting wage of over $73,000 a year. As America continues in this recession, these are the kind of jobs America needs now more than ever, high-tech, high-paying jobs for the future. And we should deal with new legislation that deals with chemicals, but we should also be careful that we're doing this in a way that keeps these jobs here in this country and not drives them over the seas where there are no regulations to deal with these issues. Just about everything we come into contact with throughout the day can be traced to chemistry companies that help improve our lives and make them better. However, we know there are some harmful chemicals that are harmful to people, animals, and the environment, and proper controls must be in place. We must understand that effects may not always be immediately visible, and that all necessary precautions must be practiced at all times. So I look forward to hearing more about the specifics of what we need to do with the Toxic Substance Control Act and your thoughts on what we can do to make this environment safer for all. And with that, I yield back, Mr. Chairman.
The Chair thanks the gentleman. The next member recognized is my friend, the gentleman from Michigan, Mr. Stu Pack, Chairman of the Oversight Committee, Subcommittee rather, for 2 minutes of opening statements.
Thank you, Mr. Chairman, and congratulations on your chairmanship. And I will waive my opening statement and ask for extra time for questions.
Thank you very much. Our next speaker is the gentleman from my birth state, Mr. Gingrey, recognized for 2 minutes of opening statement.
Mr. Chairman, thank you, and thank you for holding this hearing, and I also thank Ranking Member Radonovich, and obviously these are important issues that come before the subcommittee. I have some written prepared remarks, probably would take a little more than 2 minutes. I think I'll skip those and just speak off the cuff. Mr. Chairman, I have a BS, Bachelor of Science in Chemistry from Georgia Tech, and I am a medical doctor, as my colleagues know. I can remember as a youngster seeing DuPont ads on television. I think their slogan was "Better Living Through Chemistry." I believe it was DuPont. But, you know, I think what I've heard so far in the opening statements of my colleagues is that there are concerns and that this is a 30-year-old law and it needs to be looked at very carefully and possibly updated. From my side of the rostrum, I think what you're hearing is we don't want to overshoot, and I can think of so many things since I've been here in my 3 terms, and this Community Reinvestment Act back in the late 70s and the unintended consequences of that in our current, in light of our current economic situation. So, Mr. Chairman, I think that I'm very happy as a new member of the subcommittee and the committee to be here at this type of hearing. I want to hear very carefully from both panels and try to learn. But again, I think I agree with my colleagues on this side that we really want to make sure that we keep in mind the unintended consequences, and if we make some changes, that we do it in the right way and make sure we strike a proper balance. And with that, Mr. Chairman, I'll yield back.
The next speaker will be the gentleman from Ohio, Mr. Space, recognized for 2 minutes of opening statements.
Thank you, Mr. Chairman. I represent a district of small towns and villages and in a very rural part of Ohio, the hills of Appalachia, in fact. And perhaps the best phrase to describe those folks that I represent is decent and hardworking. And they, I think, have a right, and we have an obligation to ensure that their workplaces are safe, their children are not exposed to hazardous chemicals, and at the same time that we encourage and promote a business environment that will allow some degree of profitability. The statement has been made by, I believe, the ranking member that we should not use an elephant gun to kill a mosquito, and I certainly couldn't agree more, but at the same time, we should not use a bug light to kill an elephant. And I appreciate the opportunity to hear from our witnesses today on TSCA, because doing so allows this subcommittee to move forward in improving what is best an outdated law, and at worst, a risk to public health, environmental safety, and business innovation. I look forward to exposing exactly what is needed to bring our toxic substance regulatory policy into the 21st century and I'm also looking forward to being a part of this committee in a proactive approach to this issue. Thank you, Mr. Chairman.
The chair thanks the gentleman. The chair now recognizes the chairman of the full committee, my friend, the gentleman from California, Mr. Chairman Waxman.
Thank you very much, Mr. Chairman. I want to commend you for holding the subcommittee's first hearing in the 111th Congress on the incredibly important issue of reforming the Toxic Substances Control Act of 1976, or TSCA. This is an important day for consumers, businesses, workers, and especially for kids who are most vulnerable to the effects of toxic chemicals. Today marks the beginning of a much-needed national conversation on the use of chemicals in our communities. This conversation is long overdue. For years, it's been clear that TSCA is not living up to its intent. For example, in 1991, the Environmental Protection Agency tried to ban the use of asbestos, a known human carcinogen, but EPA's efforts were struck down on the grounds they didn't satisfy the statute's requirements. The Government Accountability Office first recommended changes to make TSCA more effective in 1994. Now, 13 years later, GAO has added EPA's assessment and control of toxic chemicals to its high-risk series, a list of the government programs most at risk for failure. GAO added only 3 issues to its high-risk list this year. The other 2 were the entire financial regulatory system and the safety of medical devices and drugs. So that gives you a sense of just how urgent GAO believes this problem is. This hearing is a good beginning to address the challenge of TSCA reform. In the coming months, we will look closely at the specific provisions of the statute and their implementation. We will learn from what has been done in the states and in other countries to create a more effective system of protecting against the dangers of toxic chemicals. In order to be successful, however, we will have to work cooperatively to ensure that a reformed TSCA achieves its essential goals to protect human health and the environment, to make decisions based on sound science, and to encourage American innovation and leadership. We need to get this right. We owe it to our children and our grandchildren to protect them from the dangers of toxic chemicals, and I look forward to meeting this challenge with Chairman Rush, Ranking Member Radonovich, Ranking Member Barton, and all the members of the committee. And finally, let me just say, I know this subcommittee will tackle many other important issues as Congress as well, and I want to commend Chairman Rush for his leadership on all these issues. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. The chair now recognizes the gentleman from Iowa, Mr. Braley, for 2 minutes of opening statement.
Thank you, Mr. Chairman, and thank you for holding this important hearing. It's an honor to serve on this subcommittee, and I think it bears mentioning that the title of this subcommittee includes the word consumer protection. That is the most important responsibility we have when it comes to issues of safety. And I can think of no greater indictment than what was included on page 3 of the memorandum prepared for every member of the committee, where it says that in the entire period of time that this act has been in effect, EPA has not attempted to ban a single chemical under this bill. And then when you see the reference in here to First President Bush's former director of EPA General Counsel, if after thousands of deaths from asbestos exposure it is virtually impossible for EPA to regulate any chemical under Section 6, what does that say about the impact of this legislation? It's important for us to have balance. It's important for us to rely upon scientific-based regulation, but it's also important for us to understand the basic purpose of this subcommittee. That's to protect consumers. It's long overdue that we take another look at this act and provide meaningful opportunities to protect consumers, despite the fact that thousands of people have died from exposure to toxic substances since 1991. And I yield back.
The chair now recognizes the gentleman from Ohio, Mr. Sutton, for 2 minutes of opening statement. She's not here. Okay, the chair now recognizes my friend of longstanding, the chairman of the Committee on Science, Mr. Gordon, for the purpose of 2 minutes of opening statement.
Thank you, Mr. Chairman. I'll waive my statement so that we can start hearing from our witnesses.
Praise God. Thank you.
We have Mr. Stearns.
Oh. Now the chair recognizes the gentleman from Florida for the purposes of 2 minutes of opening statements. Mr. Stearns, recognized for 2 minutes.
Thank you, Mr. Chairman, and I look forward to the next 2 years and the hearings we're going to have, and I appreciate you bringing up this topic, a somewhat controversial issue of industrial chemicals and the way they are currently regulated in the United States under the Toxic Substance and Control Act. I know when you look through this, it's going to be pros and cons on both sides of this, but I think it's important we have these witnesses. I appreciate them being here. The long and short of it is that we probably have to look at other models to see if they're working. If we move towards a purely European approach to regulate chemicals, such as what the Europeans are doing with their REACH program, regulation, evaluation, or authorization, restriction of chemical substances, we'll have to carefully consider that. I serve as the lead Republican on the transatlantic dialogue with the European unions. Ms. Shelley Berkeley from Las Vegas is the chairwoman, and I'm co-chair, and we've been actively involved with this issue and have had to press upon our European counterparts to ensure that the United States cosmetic industry, which is a $2 billion industry, were not taken off the shelves in Europe due to their new overly burdensome REACH requirements. And so I put that into perspective, Mr. Chairman, because a lot of U.S. industry would be hurt by this REACH program that the European unions have implemented. So I think we have an opportunity to have a constructive discussion today on this very important issue, and I thank the Chairman for this hearing. I yield back.
The chair thanks the gentleman. At this time, the chair would like to, has a unanimous consent request to enter the opening statements of the Chairman Emeritus, John Dingell, for the record. I'm not hearing any objections, so approved.